Okay, so welcome back to session 2. I hope you had a chance to digest the information from session number 1. And again, in session number 1, there was much material that we were unable to cover in the time allocated for that session. And I provided for you the PowerPoint slides associated with that material, mostly related to Codes of Regulation 40 and Codes of Regulation 41, which are the disclosure requirements and the ethical requirements. And it's essential that you understand every single section of both of those codes of regulation. Those codes of regulation are extracted from the larger grouping of regulations known as the QME regulations, and those two are of particular importance and application to us in the day-to-day face-to-face evaluations with injured workers. So make sure you're thoroughly familiar with both CCR 40 and CCR 41. So let's get on the same page as to where we are. We've now completed session number 1 of our 12-hour program. Our last session was regarding the QME's role in the disability evaluation process, and I've given you a list of references to the labor codes and codes of regulation that discuss those responsibilities of the qualified medical evaluator. So be familiar with those and review those regularly. In today's session, we're going to go on to the elements of the medical legal report. The Division of Workers' Compensation requires that we spend at least 1 hour on this material. And of course, there is much more to be discussed than we can condense into a 1 hour period of time. So we'll go for approximately an hour, maybe a little bit longer in today's session. And then again, I will provide you what I consider to be the relevant references and the relevant resources for the remainder of the content so that you have some exposure to all of the material associated with this particular topic. Okay, so let's begin today's discussion, which is regarding the elements of the medical legal report. Now, for this session, which deals with the component parts of the medical legal report, which are referred to as the elements of the medical legal report, we're going to have 3 main references that we're going to use to incorporate pieces from each of these references into constructing our own medical legal reports. And it's kind of an interesting situation because we have 3 references. We have the 2016 Physician's Guide, we have the AMA Guide's 5th edition, and then we have Regulation 10682. We're going to go over each of these and see what each of these have to say about what's required in a medical legal report. And we're going to capture some of the elements from each of these references in constructing our own high-quality, top-notch medical legal report. Now, it's very interesting because the 2016 Physician's Guide, that's a California publication. That's a publication of the Division of Workers' Compensation. CCR 10682 is a California Code of Regulation that talks about the medical legal report. So those are California-specific references, and both of those references deal with the workers' compensation system in the state of California. In contrast to that, the AMA Guide's 5th edition is not California-specific, and it's not workers' compensation specific. The AMA Guide's 5th edition talks about permanent impairment evaluations in general, not related to any particular jurisdiction. But the AMA Guides have much to say about what they consider to be the elements of a high-quality permanent impairment report. So we're going to use this guide as a reference and extract from it that which is valuable to us here in the state of California. So we're going to use these references to sort of hybridize a final report format that contains all of the elements that we need in constructing high quality reports that enhance our reputations here in the state of California. So let's take a look at some of these elements as described in these references, and we'll go through them one by one. Now, I want to give you a little bit of history that leads and gives us the sequence of events that brings us to where we are today. Now, for all of you listening to this program, your history as a qualified medical evaluator is beginning now in 2023 or perhaps in 2024, depending on when you're listening to this recording. And so you don't know about the history that's gone before you, but I want to share with you a little bit about it to provide some reference and framework for the remainder of the discussion of today's session. So back in 2001, we had what was referred to as the 2001 Physician's Guide. And the 2001 Physician's Guide was updated in 2001. Now, I've been doing qualified medical evaluations since long before 2001, and we had a different reference to tell us how to construct our medical legal reports before 2001, but the Physician's Guide was updated in 2001. And back in the day, we were using a permanent disability rating schedule referred to as the 1997 Permanent Disability Rating Schedule. So the 2001 Physician's Guide at that time was updated to accommodate the new disability rating schedule. Well, then in 2005, we had the introduction of new legislation that brought in the AMA guides as our basis upon which to conduct at least our physical examinations. And really, the AMA guides changed the entire paradigm of the workers' compensation system, not to mention just the QME evaluation. But at the time, the 2001 Physician's Guide was not updated to reflect the new requirements required by the AMA guides. And at the time, we had a code of regulation, which was 10606, which was describing what was required to be in a medical legal report related to the 1997 Permanent Disability Rating Schedule. So what I'm telling you here by sharing this history with you is that there was a mismatch of round pegs and square holes and apples and oranges comparisons, and it was a bit of a mess in the beginning. But later, 11 years later, after the introduction of the AMA guides, the Physician's Guide was updated. CCR 10606 was repealed and reintroduced as 10682. And then these references now are current references that give us what we need to include in our medical legal reports now in order to capture all of the new requirements in the new laws, and also designed to accommodate the AMA Guides 5th edition. So let's begin our discussion today by first exploring what the 2016 Physician's Guide has to say about our medical legal reports. Okay, so let's take a look here at the 2016 Physician's Guide, and I've provided this to all of you as a part of your references for this particular course. And this is going to be your go-to Bible from now on throughout the remainder of your career as a qualified medical evaluator. So let's just take a look at the contents of this book. It talks a bit about the workers' compensation system in general, how the workers' compensation system fits within the state government. There's very valuable sections for you here that you will refer to over and over again, and for which you will draw references in supporting your arguments in the future within the body of your QME reports. For the purposes of today's discussion, we're going to go down to section number 12 and talk about writing the medical legal report, and we're going to focus in on the required elements of the medical legal report. Now, of course, you should be fully aware of all of the discussion within this section, including the timeliness and the necessity for completing your report in a timely basis. We're going to focus for the purposes of this discussion on the required elements of the medical legal report. In the 2001 Physician's Guide, they give us what they refer to as their guidelines for a well-written report. And by well-written report, we're referring to a report that's rateable by the raters at the Disability Evaluation Unit. What good is a report if it's not rateable? Okay, it should be rateable the first time through. In other words, the parties should not have to request a supplemental report that costs them additional money to have you clarify some discrepancy or some inaccuracy or some omission in your report that renders your report not rateable. So we're going to talk about what are the elements that should be contained within your report in order to contribute to the things that we talked about earlier, the credibility, the accuracy and the persuasive power of your report, as well as rendering your report rateable down at the disability evaluation unit. Okay? So your report should contain should contain all of the following major topic headings. Okay, these are major topic headings that should be contained within your report. So number one is the identifying information, and we'll talk about what type of information should go in each of these sections here in a couple of minutes, but let's just elaborate on the major topic headings at this point. So identifying information. Number two is an opening statement, wherein you give the parties, where you set the stage for the parties. Number three is the sources of information. Number four is the history of present illness or injury. Number five is the present complaints, or what are the current symptoms that are related to the industrial injury. Number six is a history section, and the history section should be a thorough section in your report that contains at least three subsections. Number one is the social history. Number two is the review of systems. And number three is the relevant medical history, or relevant medical information. And it's interesting with regards to relevant medical information. Relevant medical information is an important section in your report, if for no other reason that it justifies the use of the ML 104 complexity factors for your billing under the code ML 104. One of the requirements of the ML 104 level of billing is that you produced an examination and an evaluation that involved prior multiple injuries to the same body parts as the current body part that you're evaluating for the current industrial injury. So it's under the relevant medical history section of your report that you would justify and expand upon the use of that particular complexity factor. Number seven is your physical examination section. Number eight is your diagnosis. Number nine is the causation of the disability. Number 10 is the permanent and stationary opinion that you're going to provide. Number 11 are the factors of disability, at least as those are described in the 2001 Physician's Guide. And as I said, we no longer provide for permanent disability. We now provide for permanent impairment. And I say that with the caveat that at least for injuries after 1105, we provide for permanent impairment. And in certain cases where the date of injury is prior to 1105, we will be providing for factors of disability as related to the 1997 permanent disability rating schedule. But at this date, those instances are becoming rarer and rarer, and more of our work involves opinions on permanent impairment. Okay? Number 12 is our opinion on apportionment. Section 13 is where you discuss the medical treatment that the injured worker has received to date. In Section 14, you talk about either further medical treatment or the need for future medical treatment. And then with Sections 15 and 16, we conclude the report. And in Section 15, you provide your reasons for opinion. And let me just say a couple of comments about reasons for opinion. The reasons for your opinions and your conclusions has become increasingly important and introduces a new topic which we'll simply entitle, quote, substantial medical evidence, unquote. And I'll talk more about substantial medical evidence in just a little bit in this program, but substantial medical evidence is the new standard that our opinions and conclusions must rise to and adhere to in order to qualify as opinions and conclusions that the parties can use. And in order for opinions, very briefly here, in order for opinions to qualify as substantial medical evidence, the opinion and or conclusion has to be supported with the reasons for the opinion or conclusion. And this is referred to in the industry as the how and the why. How and why. You must explain how and why you arrived at your opinion or conclusion. we'll talk more about that, but there's a specific section in our reports that will qualify our report as substantial medical evidence. And then finally, you conclude your report with the mandatory disclosures and declarations with your signature, your disclosure of significant financial interest, and then also the date that your report is mailed to the parties, and also an indication as to what county the report was mailed from. Okay, so those are the report elements, required report elements as required by the 2001's Physician's Guide. And we'll get into a couple of comments about the AMA guides in just a minute. And then what we're going to do is we're going to take the requirements of both systems, both the 2001 Physician's Guide and then also the AMA Guides 5th edition, and we're going to come up with sort of what I refer to as a hybrid report format that encompasses and includes all of the required elements, that is, all of the elements required by both the 2001 Physician's Guide and all of the elements required by the 2005 AMA Guides 5th edition, which will provide us with a report that contains every possible report element required to resolve contested issues in the workers' compensation system, and does not contain superfluous, extraneous, and duplicative report sections. So what I'm going to provide for you is an exact report format that you can use to fashion your own reports after. That'll be coming up in just a couple moments. Okay, so let's do a couple things now. Let's take a look at our two references for the required elements of the medical legal report. The first one of which is the 2016 Physician's Guide, so let's look at that first. And then we'll take a look at the AMA Guides 5th edition and see what it has to say about what's required in reporting, at least on permanent impairments. So what we're going to do is we're going to take these two references, the 2016 Physician's Guide and the AMA Guides 5th edition, and we're going to harvest or extract from both of these references the elements that we need to create the perfect and compliant QME report. So I want to point out a couple of things here in the 2016 Physician's Guide. If we go to the table of contents, with regards to report writing, there's a couple of chapters that are relevant to us as qualified medical evaluators. So the first one of which is Chapter 7 right here, which talks about reports and timelines in the system. And we're not going to review this chapter because for our purposes, most of the reports that they're talking about in this particular chapter have to deal with primary treating physicians, and we are the qualified medical evaluators. So all of these reports here are reports that are related to the primary treating physician. But I just want to point out here that there's a section in this chapter dealing with the importance of timely reports and timely reporting by us as qualified medical evaluators. And it's important that you remember that on the other side of your report is an injured worker, is an injured worker's family, are the parties, including the claims administrator, a couple of attorneys, and people rely on our reports. And therefore, it's very important that our reports be timely. Now, by law, we have up to 30 days as qualified medical evaluators to submit our written report. We have up to 30 days after the face-to-face evaluation before our report is considered to be quote-unquote overdue. But I want to encourage you to complete your reports much, much quicker than 30 days. I want to encourage you to complete your reports in the shortest time possible so that you can keep the system moving and keep benefits flowing in those circumstances where injured workers are awaiting the receipt of benefits. So that's Chapter 7. And then the next chapter dealing with the report is Chapter 12. And again, you'll notice, and I want to point this out, that again, there's another section in Chapter 12 about the timeliness of reports. So whenever you have a face-to-face evaluation with an injured worker, I want you to set a goal to have your report done in no longer than 14 days. High-performing QMEs get their reports out lickety-split in no time at all. Low-performing QMEs submit their report on the 29th or the 30th day after the face-to-face evaluation. Meanwhile, on the other end of that report, an injured worker is waiting waiting for your report. So I want to encourage you to focus on getting your reports out very, very quickly. Okay, so let's go to page 65 in the 2016 Physician's Guide. And this is Chapter 12, Writing the Medical Legal Report. So we've already spent some time regarding the required elements of the medical legal report, and I just want you to see this with your own eyes, how it looks here in Chapter 12. So here's the topic heading, Required Elements, and it tells us that the required elements are listed in Table 12-1. And here are the required elements of a medical legal report. And this is described in law. The law is not referenced here, but the law is California Code of Regulations 10606. So this is taken directly from the Code of Regulation 10606. And it talks about all of the elements that are required to be in the report. And these, we've already gone over these, so we're not going to rehash these. But let's just go through into the text of the chapter here. And it lists all of the things that we've already talked about: the identifying information, the opening statement, the sources of information, and all of the elements that are required to be in your QME report. Now, when you get out in the field as a qualified medical evaluator, you're going to need to construct your template to include all of these required elements. If you do not have a template or you want a template, we have these templates available for you. They're already pre-constructed. Many of the sections of these of the report are already pre-populated with much of the necessary information. In other words, the wheel has already been invented, and if you need a template, you can get those templates from us. Okay, so this is the 2016 Physician's Guide, and it tells us what's required in a QME report in California workers' compensation. Now, it's very, very interesting because the 2016 Physician's Guide, this is a California-specific document. Well, very interestingly, we also, in California workers' compensation, we use the AMA Guides 5th edition. And the AMA Guides 5th edition is not California-specific, but the AMA Guides 5th edition is permanent impairment evaluation specific. So the AMA Guides has something to say about what the AMA Guides authors consider to be the required elements in a permanent impairment evaluation. So because we do permanent impairment evaluations here in California workers' compensation, we're going to harvest some of the elements that are described in the AMA Guides, and let's review those right now. Okay, so the AMA Guides require that we have a section in our report entitled The Narrative History, with work history being optional, but we'll talk more about that in our hybrid format in just a minute. They require that we elaborate on the current clinical status, and that includes what they describe as the chief complaint, the review of systems, and the physical examination. And you'll notice here that I've put review of systems in bold, and I want to emphasize the review of systems because I found that not many doctors actually perform a good or any review of systems. And I believe it to be important because the AMA Guides state specifically on page 18 of the guides, they say that the physician needs to ensure that the examinee understands that the evaluation's purpose is medical assessment, not medical treatment. So we're not there to provide medical treatment. We're there to perform an assessment to determine their current condition, specifically as relates to the presence or absence of permanent impairment. However, if new diagnoses are discovered, the physician has a medical obligation to inform the requesting party and the individual about the condition and recommend further medical assessment. And this is particularly appropriate. Specifically, I can cite at least one case in my own experience where my physical examination uncovered an examinee who had the early stages of Parkinson's disease. Now, the Parkinson's disease obviously was not caused by the industrial injury, but the individual simultaneously had the development and ongoing progression of Parkinson's disease. And I discovered it during physical examination. He thought that perhaps his symptoms were related to the industrial injury, but I attributed those symptoms to something different, to some different type of neurologic disorder, and it turned out to be Parkinson's disease. Well, we were able to get him an assessment, at least under the industrial injury, for these strange symptoms, which turned out to be non-industrial in nature. But we helped this individual to obtain proper medical treatment for a health condition that certainly was at least as important, if not more important to him than the industrial injury. So I want to encourage you to integrate and implement a good review of systems in your standard procedure. AMA guides require that we include a section entitled the Diagnostic Study Results. They require that we report on maximum medical improvement of the condition. And we're going to hybridize the concepts of permanent and stationary with maximum medical improvement in our hybrid format. They require that we have a section entitled the Diagnoses and the Permanent Impairments. And it's important that the diagnoses correlate with the permanent impairments. Many doctors put down diagnoses that have no connection or no relationship or no consistency with the permanent impairments that's described by the doctor. And this is a report writing inconsistency. The diagnoses and the impairments should be consistent. We're required to describe our impairment rating criteria. We're required to describe our impairment rating. And then we're required to calculate the permanent impairment rating and explain how and why we arrived at a particular permanent impairment rating. So like we did with the 2001 Physician's Guide, I want to ask you, how many of you doctors are using this format in its exact description? Probably not many of you, because we don't use this exact formatting here in the California Workers' Compensation System. But there are parts of this suggested report writing format that we can integrate into our hybrid QME template to include the important elements, specifically as relates to the permanent impairments. And I'll show you how just such a report will look in just a couple moments. So you'll notice here I have a table for you wherein we sort of compare the 2001 Physician's Guide with the AMA Guide's 5th edition. And you'll notice that the requirements of the AMA Guide's 5th edition is substantially less than what is required by the 2001 Physician's Guide. And we already alluded to the reason as to why, and that is because the AMA Guide's 5th edition is not intended to address workers' compensation issues. So you'll notice also that the Physician's Guide and the Guide's 5th edition have some components that are roughly the same and or similar. So for example, I have here highlighted in light blue, under the 2001 Physician's Guide, we have a section of our report entitled The History. Well, the AMA Guide describes that as the narrative history and or the work history. So we're going to sort of adopt the two formats and create a hybrid format. But what we're going to do is we're going to separate out the work history from the history of the current injury and or condition. You'll see here I have highlighted in red that the 2001 Physician's Guide talks about the history of present illness or injury. Well, that's roughly similar to what the AMA Guides describe as the current clinical status, wherein the chief complaint, the review of systems, and the physical examination is described. So we're going to sort of hybridize those headings as well, although of course we're going to separate out the physical examination from the chief complaints and the history of present injury or illness. In California Workers' Compensation, we talk about permanent and stationary. whereas the AMA guides refers to maximum medical improvement. And those are separate and distinct types of issues, but they're closely related, and I'll show you how we hybridize and combined those two ideas into one section of our report. And then finally, whereas the 2001 Physician's Guide has a section where we describe the factors of disability, in the AMA guides, we're going to talk about the impairment rating for injuries after 1105. So let's go in now to our sort of hybrid format that includes all the elements required by both the 2001 Physician's Guide and also by the AMA Guides 5th edition. And we'll elaborate on each of these a little bit more as we go, and specifically when we get to our QME template where I show you how all of this gets formatted into a clear and cohesive report. We're going to elaborate extensively on number 1, the identifying information, number 2, the opening statement, number 3, the history, 4, the relevant medical history. We'll go over extensively number 6, the review of records. And then also we'll talk about activities of daily living and symptom questionnaires. So these are all elements that we're going to include in our current report writing template to cover all dates of injury, both before and after 1105. We're also going to include a section where we talk about the occupational history. The AMA guides refer to that as work history. We're going to have a section entitled the Review of Systems. We're going to have a section entitled the Claimant Report of Symptoms. And isn't that a much more politically correct term than is claimant complaints? I think report of symptoms is much more politically correct, because the claimant is going to report to us what their physical symptoms are as relates to the industrial injury. We're going to have an extensive section entitled the Activities of Daily Living Assessments and Symptoms Questionnaires. And this is an interesting section because nowhere in the 2001 Physician's Guides are we required to report on activities of daily living, except to the extent that pain or the examinee's subjective factors of disability may interfere with various activities. On the other hand, the AMA guides is all about activities of daily living. In fact, the entirety of the concept of permanent impairment is related on adverse impact on activities of daily living. So we're going to have an extensive section, a thorough section, and a masterpiece of a section of our report that deals with our assessment of activities of daily living. And I've reported on this in other QME home study continuing education programs and courses. So if you have not heard this discussion now, you can find a complete course on activities of daily living on my website, which is www.ezqmeceu.com, or you can find videos on this procedure exactly as I teach it on YouTube. So you would simply go to YouTube and type in Perry Carpenter DC, and there's several videos there as to how to perform an activities of daily living assessment in the face-to-face evaluation with your examinee. We're going to also have a section in our report entitled the Physical Examination, of course. We're going to have a section wherein we report separately on the diagnostic studies. If any medical research is required, we'll have a separate section so that that stands out as a separate and distinct part of our report. We'll have a section on diagnosis of current condition. We'll have a couple of sections on causation, depending upon the nature of the report. As you know, causation refers to both the AOE, COE, and that is whether or not the injury arose out of employment or occurred in the course of employment. So that refers to really the presence or absence of an industrial injury. In other words, an injury that's compensable. Well, we'll also have another causation section, and we'll talk about that in just a moment. We'll have a section wherein we describe the permanent and stationary / maximum medical improvement status. We're going to have a section of our report specifically devoted to the permanent impairment. And as I said earlier, for injuries prior to 1105, we will use the title Factors of Disability rather than the title Permanent Impairment for this section. We're going to have a section where we calculate the impairment rating and describe our methodology in arriving at the permanent impairment rating. We'll have another section on causation if indeed we find the applicant to be permanent and stationary and suffering from some degree of permanent impairment. We'll have a section wherein we describe the apportionment of the permanent impairment based upon causation. So in this circumstance, the causation related to AOE, COE would probably not be an issue because by this point in time, the industrial injury has already been admitted and has been accepted. But we'll still discuss the causation of the apportionment of the permanent impairment. We'll have a section wherein we describe either further or future medical care, depending upon whether the applicant is indeed permanent and stationary or not. Then we'll finish up our report with a section on the work status or any work restrictions that may be appropriate for the examinee. And then, like we did with our 2001 Physician's Guide, we're going to have all of the mandatory disclosures and mandatory declarations that bring our reports in compliance with all of the labor codes and codes of regulation that govern these reports. Okay, so let's break down some of these sections and go into these in detail, and then I'll show you how these sections would look in your actual QME report. And before we get to our QME report template and show how all of this material comes together in an actual QME report, let's spend some time talking about some more of the provisions, regulations, and codes that govern the formulation of our QME reports. And what I want to talk to you about now are the labor codes and the regulation requirements for medical legal reports. And this is going to be important for you to use as a check sheet against which you can compare your QME reports to see how well you satisfy the current requirements, which basically give us our obligation as to how to construct and what information to contain within the body of our QME reports. So what I want to share with you now includes some important labor codes and some important regulations, specifically California Codes of Regulation 35.5 and then Labor Code 4628, which are going to be important codes for you to be familiar with throughout the entire lifetime of your career as a qualified medical evaluator. And let me just give an example of that. I received a call from a QME evaluator just the other day who received an unusual request in the mail. It seems that a defense attorney requested that the qualified medical evaluator provide a copy of his curriculum vitae. And this came as a surprise to the evaluator because the case in question was a case that the qualified medical evaluator had reported upon approximately 8 to 10 months earlier. So without hearing anything at all about the case, 8 to 10 months after his qualified medical evaluation, he receives a letter from a defense attorney which requests a copy of his curriculum vitae. And he wondered, well, what could be the purpose of the defense attorney requesting a copy of my CV? And should I do it? Do I have to do it? And do I charge for sending this out? Is this like something that qualifies as a supplemental report? Well, the curriculum vitae is described specifically in Labor Code 4628, and it's an example of one of those subtle nuances that we may learn one time and then forget about, or we may be completely unaware of these codes and of these regulations. So I'm going to go over these codes and regulations painstakingly because they impact the day-to-day work that we do, and you never know when these labor codes may come up. So let's talk about first California Code of Regulation Title 8, 35.35. And there's several sections of importance to us within this regulation. Let's begin with Section B, which says that each reporting evaluator shall state in the body of the comprehensive medical legal report the date the examination was completed, and the street address at which the examination was performed. If the evaluator signs the report on any date other than the date the examination was completed, the evaluator shall enter the date the report is signed next to or near the signature on the report. Now, we've talked about the proper dating of your QME report, so let's talk about sentence number 1 here in Code Section B. And that has to do with the location where the qualified medical examination was performed. And let me just go on record here as saying that the administrative director and the DWC medical unit are very, very serious about locations. And in fact, there's a regulation that says that the initial qualified medical evaluation can be done at no address other than the address that's listed on the QME panel. So if you're one of those QME doctors that has multiple satellite locations, you may run into some scheduling difficulty with the satellite location. And I'm just making this up, but let me give you an example. Let's say you go to schedule your appointment at a satellite location, and the location says the office is not available for any of those times. Well, you know that you have several satellite locations. In fact, there's a satellite location very near to the location that's listed on the QME panel. And you figure, well, it's not going to be any difference to anybody. I'll just move the appointment from location A to location B. And the administrative director does not take kindly to that. Does not take kindly to that. Now, for subsequent evaluations, you do have the authority to move the examinee around to different locations as long as the examinee has no objection to that. But at least for the initial report, it has to be done at the location designated on the QME panel. Now, if for some reason you're unable to schedule at that location, then you're going to have to sacrifice this evaluation. There simply is no other way around it. And the administrative director tracks this through Regulation 35.5b, which tells us that we have to state where we did the examination, and do not fabricate or do not change the address, or do not state that you did it at such and such address when you actually did not, because this is grounds for QME discipline. Okay, and I'll show you how this looks within the body of your report in just a few minutes. Okay, let's go on to section C number 1. It says the evaluator shall address all contested medical issues arising from all injuries reported on one or more claim forms prior to the date of the employee's appointment with the medical evaluator that are issues within the evaluator's scope of practice and areas of clinical competence. The reporting evaluator shall attempt to address each question raised by each party in the issue cover letter sent to the evaluator as provided in subdivision A3. And we talked a little bit about this earlier as well. Make sure to address all questions, even if it seems like the questions are simply templated form letter questions. Address all questions. Now, the regulation describes one or more claim forms. Now, we as medical evaluators rarely have access to the claim forms. Now, sometimes we do, sometimes they're included in the medical records that we receive, but we don't always have access to those, and so we may or may not be aware of all the contested medical issues, and we may or may not be aware of all injuries. So for that reason, we rely on the cover letters. And it's never a bad idea to confirm the scope of your evaluation if there's any uncertainty to you after you receive the cover letter. And I've done that on many occasions. For example, I'll be reviewing the medical records which show treatment to body parts that are not listed in the cover letter. And then I may contact one or more of the parties in writing, of course, to avoid accusations of ex parte communication. But I may contact one or more of the parties to request clarification on the scope of the evaluation. For example, I may request whether or not The elbow, for example, is something that should be part of my evaluation. So feel free to do that if you ever have uncertainty as to the scope of your evaluation. Now, if the evaluator, this is section C2, if the evaluator declares the injured worker to be permanent and stationary for the body part evaluated, and the evaluator finds that the injury has caused permanent partial disability, the evaluator shall complete the physician's report of permanent and stationary status and work capacity and serve it on the claims administrator together with the medical report. And I believe that is fairly self-explanatory. Okay, section 35.5D now says, at the evaluator's earliest opportunity, and certainly no later than the date the report is served, the evaluator shall advise the parties in writing of any disputed medical issues that are outside of the evaluator's scope of practice and area of clinical competency, in order that the parties may initiate the process for obtaining an additional evaluation pursuant to section 4062.1 and 4062.2 of the Labor Code in another specialty. And remember that Labor Code 4062.1 and 4062.2 deal with represented and unrepresented, or vice versa, unrepresented and represented injured workers. So this regulation deals with those cases wherein you find issues outside of your scope of practice. And let me give you an example. So as an example, I'm a chiropractor. So if I'm doing an evaluation and I discover that my examinee has problems with depression, well, that would require an opinion and an evaluation from a psychology or psychiatry provider. Or let's say I'm a chiropractor and I discover, or my examinee reports, symptoms related to the genitourinary system. For example, they're reporting sexual dysfunction, or they're reporting dribbling of urine, or they're reporting incontinence of feces, perhaps related to a spinal cord condition. These are conditions that would require evaluation by an evaluator in another specialty. And this is the procedure that's involved with that. It says, in the case of an agreed panel QME or the panel QME, and this tells you how old this regulation is, since we no longer have the designation of the agreed panel QME. But anyway, it says the evaluator shall send a copy of the written notification provided to the parties also to the medical director at the same time. So we're required to send a copy of this notification to the medical director. Why is that? So that the medical director can then issue a new panel. However, only a party's request for an additional panel with the evaluator's written notice under this section attached, or an order by a workers' compensation administrative law judge, will be acted upon by the medical director to issue a new QME panel in another specialty in the claim. So this reinforces the power and the necessity of your written notification, doctor. Without the written notification from you of the need for an additional evaluation, no other party, unless there's an order by a workers' comp law judge, no other party can simply unilaterally or bilaterally order a new panel. So it's imperative upon us that as soon as possible, in order to keep this claim moving forward, we need to notify the parties of this issue. Okay? Okay, let's move on now to Labor Code 4628. Okay, Labor Code 4628, as I referred to earlier, is an important labor code, and this one you will come across dozens and dozens of times in your career, and it contains many sections and many provisions, and we're going to go through this labor code painstakingly so that we're all on the same page with its requirements. And it gives us great information about how to construct our QME reports. So beginning with Section A of Labor Code 4628 says, except as provided in Subdivision C, we'll get to C in just a minute, it says no person other than the physician who signs the medical legal report, except for a nurse performing those functions routinely performed by a nurse, such as taking blood pressure, shall examine the injured employee or participate in the non-clerical preparation of the report, including all of the following: taking a complete history, reviewing and summarizing prior medical records, and composing and drafting the conclusions of the report. So what is this saying? It's saying that you, as the qualified medical evaluator, are responsible for the examination of the injured worker. You're responsible for taking a complete history. You're responsible for reviewing and summarizing the prior medical records, and you're responsible for composing and drafting the conclusions of the report. So in other words, all of this work has to be done by you. You can't delegate or designate someone else to do the examination, and you can't delegate or designate someone else to compose and draft the conclusions of your report. The conclusions of the report have to be your own. And this is interesting because this prevents anyone else from writing your QME report for you. And certainly throughout history, there have been occasions where doctors have paid other report writers to write their reports for them for a fee. And this section of Labor Code 4628 prevents that. Okay, let's go on to Section B. It says the report shall disclose the date when and the location where the evaluation was performed. And you'll notice that this is a reiteration of the regulation in 35.5. So this suggests to us that the administrative director is very serious about the location issue. And I think I've spoken about that so that you get that point. The report shall disclose that the physician or physician who signs the report actually performed the evaluation. The report shall disclose whether the evaluation performed and the time spent performing the evaluation was in compliance with the guidelines established by the administrative director pursuant to paragraph 5 of subdivision J of Labor Code section 139.2 or section 5307.6. And we're going to go over those sections here as well. These are the administrative director's guidelines and time guidelines for QME evaluations of different regions of the body. The report shall disclose the name and qualifications of each person who performed any services in connection with the report, including diagnostic studies other than its clerical preparation. By clerical preparation, they're referring to transcription services. So any person who performs diagnostic services or diagnostic studies in connection with the evaluation, you need to disclose their name and their qualifications. Finally, it says if the report discloses that the evaluation performed or the time spent performing the evaluation was not in compliance with the guidelines established by the administrative director, and that's these code sections and labor codes and regulations right here, the report shall explain in detail any variance and the reasons or reasons therefore. Okay, so the administrative director is tucking us in here to make sure that we do our reports according to these guidelines. And how does she do that? She does that by requiring our signature and a disclosure that we complied with all of these requirements. And I'll show you how that looks within the body of your report here as we go. Okay, Section C says that if the initial outline of a patient's history or the excerpting of prior medical records is not done by the physician shall review the excerpts and the entire outline and shall make additional inquiries and examinations as are necessary and appropriate to identify and determine the relevant medical issues. So what is this saying? Well, many doctors consider themselves way too busy to review medical records. They're way too busy to deal with the stack of medical records that comes to their door delivered by FedEx, and they're too busy to take those records and sort them in date order and review those records and extract from those records salient and important points and notations. They're too busy for that. So they delegate and designate this duty to a third party. And there are many review of records companies that do this service. Well, that's all well and good, and the administrative director does allow this. However, the administrative director requires that if this is done, if this excerpting is done, then the physician shall review the excerpts and not simply accept the excerpts at face value, but shall make additional inquiries and examinations as those inquiries and examinations are appropriate. Now, in my personal opinion, I always review the entirety of the medical records myself. Why do I choose to do that? Am I not busy? Yes, I'm busy. I'm as busy as any other busy doctor, but it's my experience and my opinion that the excerpting of prior medical records is not something that can be delegated to a third-party reviewer in Pakistan, in India, or even someone locally in the United States, or even in your own city, who does not have the experience, the education, the training, and the medical expertise that we do in order to intelligently and appropriately extract the relevant data from the records. I mean, how can someone else decide for you what's relevant? What's relevant is what you determine to be relevant to you. No one else can do this for us. And so I always do the entirety of the review of records myself. And we'll talk more about review of records here as we go. But it's my opinion that the review of records component of your evaluation is extremely critical, because the medical records describe the entirety of the medical treatment history of your examinee, and there's many details contained within these medical records and medical reports that simply cannot be understood by a third-party reviewer not intimately involved with the case as you are. So again, I always recommend that the review of records be done by the doctors themselves, and that's my suggestion to you as well. I believe this will pay great dividends for you in terms of the quality of your report and your complete knowledge of the case, should the case become complex and not settle immediately. For example, if the case should go to deposition, you're probably going to have to go ahead and review the entirety of the medical records yourself again anyway, just in case questions regarding those records should come up at deposition. So why go through that half speed initially and full speed later? Why not just do it correctly the first time through? Section D says that no amount may be charged in excess of the direct charges for the physician's professional services and the reasonable cost of laboratory examinations, diagnostic studies, and other medical tests, and reasonable costs of clerical expense necessary to producing the report. Direct charges for the physician's professional services already includes reasonable overhead expenses. So what they're saying here is, if you do these diagnostic tests and you use these other persons, for example, to perform your diagnostic tests, you can't overcharge and overbill rates in excess of the physician's professional service fees. Okay, so the administrative director has obviously had experience with this, has had experience with excess charges, and has constructed this provision within Labor Code 4628 to prevent excess charges. Section E says failure to comply with the requirements of this section shall make the report inadmissible as evidence and shall eliminate any liability for payment of any medical legal expense incurred in connection with the report. Isn't that interesting? What is this? How does this relate to us? Well, this relates to us in that we can go through an entire evaluation, and we can go through the process, the lengthy process of completing our entire report, and not only have the report struck, but have the liability for payment of the report absolved, and we could end up receiving no payment for that report and no payment for our evaluation at all. Does that make it important to know this labor code? Yes, if you specifically want to get paid, it does. Further, they say, if you knowingly fail to comply with the requirements of this section, it shall subject the physician to a civil penalty of up to $1,000 for each violation, and that's to be assessed by the workers' compensation judge or the appeals board. So, is it necessary to include the disclosures? Absolutely. Can you omit the disclosures if, for example, you know that you did not comply with one of the disclosures? Can you just omit the disclosure rather than include the disclosure, which would be an outright lie? Can you just omit it? Well, here it says, no, you cannot. You cannot just omit it, and you cannot knowingly fail to comply. Otherwise, you can be severely punished. So, why does the administrative director have this labor code? She has this labor code in order to put some sanity into the reporting process and to put some structure and some format and some requirements into the reporting structure that we as qualified medical evaluators have to follow. Otherwise, what would happen? Well, there would be no structure, and the administrative director has already dealt with that. And that's why she's come up with these regulations. Okay? Couple more sections of Labor Code 4628. Section G says a physician who is assessed a civil penalty may be terminated, suspended, or placed on probation as a QME. And you don't want that. You do not want that. It's too expensive. It's too stressful. It removes you from the QME panel process, and you cannot receive cases if you're terminated or suspended. If you're on probation, you can still see QME cases, but it's a hassle because you may be required to disclose to the examinee that you're on probation. And you're supposed to give the examinee the opportunity to decide whether or not they want to follow through with you as their evaluator or whether or not they want to get a new evaluator. So even if you're on probation, still allowed to see examinees, it's a pain and it's a hassle and it's uncomfortable, and you do not want to go there. Okay? It says, knowing failure to comply with the requirements of this section shall subject the physician to contempt pursuant to the judicial powers vested in the appeals board. Any person billing for medical legal evaluations, diagnostic procedures, or diagnostic services performed by persons other than those employed by the reporting physician or physicians, or a medical corporation owned by the reporting physician or physicians, shall specify the amount paid or to be paid to those persons for the evaluations, procedures, or services. This subdivision shall not apply to any procedure or service defined or valued pursuant to section 5307.1. So, I think you can tell that the administrative director is quite sensitive about the use of outside services, particularly those services that may represent a conflict of interest. Okay, and let's finish up now with Labor Code 4628 with two more sections. Section J says, and this is one of the declarations that will go at the end of your report, it shall contain a declaration by the physician signing the report under penalty of perjury, which states, I declare under penalty of perjury that the information contained in this report and its attachments, if any, is true and correct to the best of my knowledge and belief, except as to information that I have indicated I received from others. As to that information, I declare under penalty of perjury that the information accurately describes the information provided to me, and, except as noted herein, that I believe it to be true. What does this mean? What does this mean? I declare under penalty of perjury that the information accurately describes the information provided to me. Recall earlier in one of our labor codes or one of our regulations, we were required to list and summarize the information that we received from the parties. Well, is it permissible to review some medical records but omit listing and summarizing some of those medical records? In other words, could you learn information about the examinee but not declare it by omitting it in the review of records section of your report? In other words, could you inaccurately describe the information that was provided to you? Yes, you could do that, couldn't you? You could do that. You could omit to admit that you received certain information, but the administrative director blocks you from doing so by having you sign this declaration, which requires that you accurately describe the information provided to you. And it's interesting because there are checks and balances built within this system. For example, when you receive medical records, many times those medical records will come from the claims administrator, for example. Well, the claims administrator will generally send you a log or a summary of the documents. In addition to all the documents, they'll send you a summary of the documents. Why do they do that? They do that so that they can track what they sent you. You should always check their summary. You should make sure that what they're summarizing that they send you, they actually send you. Because if you don't, there could be records there that they say in their summary that they sent you that they did not actually send you. And in your review of records, your list and summary of the records would not be consistent with their summary of what they sent you. There would be an inconsistency between the two summaries. So always check the summary that one or more of the parties send you. Why? So that you can protect yourself against inaccurately describing the information provided to you. The foregoing declaration shall be dated and signed by the reporting physician and shall indicate the county wherein it was signed. Okay, and then finally, Section K, and this one is the one that refers to the doctor's curriculum vitae, says that upon request, the physician shall provide a curriculum vitae and include a statement concerning the percent of the physician's total practice time that is annually devoted to medical treatment. And I myself have never received this as a request. But I mentioned that one of my colleagues was recently responding exactly to this request, and the defense attorney that was requesting a curriculum vitae quoted Labor Code Section 4628 and also quoted the earlier sections of 4628, wherein, and that was Section H, no, I'm sorry, that was Section F. Section F, no, I'm sorry, it was Section E. Section E, recall, said that failure to comply with the requirements of this section shall make the report inadmissible as evidence and shall eliminate any liability of payment. Now, according to my doctor colleague, he had already been paid, but apparently the report was still hung up and the case was still hung up. And possibly for that reason, and this is just speculative, I don't really know, but possibly that would be the reason that the defense attorney would then later ask for a curriculum vitae. Perhaps the defense attorney, as a strategy, was looking to have the report declared to be inadmissible as evidence. So you may come across occasions wherein you are required to provide your curriculum vitae in accordance with 4628 Section K. Section K. Okay, so that's Labor Code 4628, and wow, what a powerful labor code that is. It really tucks us in tight as to how we perform and how we behave during our qualified medical evaluations, and it tucks us in tight with declarations and signatures. So I recommend that you review this labor code frequently, especially with regards to the finances of other persons involved with the production of the report. Okay, and then I want to finish up this section with just a brief discussion about Labor Code 139.3, and then we're going to shift gears and talk more about issues related to the mechanics of putting together your qualified medical evaluation report. So let's talk about Labor Code Section 139.3. This is also known as the No Self-Referrals Labor Code. And why would the administrative director have an entire code that prevents self-referrals? Because the administrative director is concerned that we as medical evaluators be neutral, that we be objective, that we be unbiased, that we perform our evaluations and carry ourselves professionally and with the utmost of propriety. And that propriety and professionalism can become compromised with the opportunity to refer for services that represent a conflict of interest, wherein the evaluating doctor serves to benefit or gain income from those referrals. So Section A of 139.3 says, notwithstanding any other law, to the extent those services are paid pursuant to Division 4, commencing with Section 3200, it is unlawful for a physician to refer a person for many services, for example, for clinical laboratory services, diagnostic nuclear medicine services, for radiation oncology services, physical therapy, physical rehabilitation, psychometric testing, home infusion therapy, outpatient surgery, diagnostic imaging goods or services, or pharmacy goods, whether for treatment or medical legal purposes, if the physician or his or her immediate family has a financial interest with the person or in the entity that receives the referral. And at the time this program is being reported, a major shockwave just went through the QME industry here in California, where a medical doctor was arrested for workers' compensation fraud by having many self-referrals for urine toxicology testing. Yes, he was running a urine toxicology testing service and was involved with all kinds of improprieties and was actually arrested. And it was a big story here in California. So again, the administrative director is concerned that we not have any vested interest other than simply providing true and accurate opinions and conclusions in the case, that we not be involved in the outcome, not be vested in the outcome, and that we not have any conflicts of interest regarding the examinee. They simply want us to provide unbiased, objective, and neutral opinions that are a true and accurate representation of the examinee's condition on the day of our evaluation. And they have many codes and regulations, including the anti-self-referral regulation, to block us from such conflicts of interest. Okay, so at this point, I'd like to take a little break. I'll give you a chance to maybe get something to drink or get a snack. And then we're going to shift gears a little bit and begin our discussion on the anatomy and the mechanics of putting together our qualified medical evaluation reports. Okay, so I'll be back with you in just a couple moments. Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on today's video. On today's video, I want to go over a very important topic with you, and that is the concept and the topic related to substantial medical evidence. Substantial medical evidence. Now, I find that doctors fall into two basic categories. There's those doctors who are familiar with the term and the concept of substantial medical evidence, and then there's doctors who are not, doctors who have never heard of the phraseology of substantial medical evidence and have no idea as to what constitutes substantial medical evidence in their QME reporting. So I want to talk today about substantial medical evidence. And I want to emphasize the importance of making sure that in every single opinion and every single conclusion that you offer in your QME report, you substantiate that opinion and conclusion in order to make that opinion and conclusion qualify as evidence that the parties qualify as substantial. In other words, your opinions and your conclusions have to be substantial, meaning they have to be substantiable and they have to be substantiated. And many times doctors provide opinions and conclusions in their QME reports that are not substantiated. And the term that's used when opinions and conclusions are not substantiated is the term is called conclusory. Conclusory. And what conclusory means is that the doctor has simply provided a conclusion, an opinion or a conclusion without substantiating it. So let me give you an example of what a conclusory opinion is. Conclusory opinion would be, for example, in my opinion, Mrs. Jones became permanent and stationary on June 14, 2014, period. That is a conclusory opinion. And it's not a substantial opinion, and it doesn't qualify as substantial medical evidence because the doctor does not explain how and why he concludes that that was the permanent and stationary date. You see, it's simply not enough to provide your opinion and conclusion. You have to substantiate your opinion and conclusions with your reasoning as to how and your reasoning as to why. So we want to give you some suggestions and some ideas. First of all, about the concepts of substantial medical evidence, and then number two, some ideas and some suggestions for preparing your QME reports to make sure that when your QME report leaves the office for the mailbox, that you've dotted every I and crossed every T of every opinion and conclusion in your report, so that your report indeed does qualify as substantial medical evidence, and that your report will stand up and your opinions and conclusions will be upheld and withheld. Okay, and then at the very end of the program, I want to give you a special gift. It's a little template that you can use to cut and paste into your reports to demonstrate to the parties that indeed you have duly considered all of your opinions and conclusions, and you put by your signature, you put your stamp of approval on each of the opinions and conclusions by yourself personally qualifying each of your opinions and conclusions as substantial medical evidence, and then explaining the reasoning as to how and why you arrive at those conclusions. So I'll have that for you as a special digital download at the end of this brief video. Okay, so let's begin. Now, substantial medical evidence was really solidified recently in the Escobedo case, but substantial medical evidence has been a topic in legal writings going way back. And specific citations that I was able to locate go back as far as even in the 70s and early 80s with the Granado and Zemke cases. But most recently, we rely on the definitions derived from the Escobedo case for our most current recipe. Let's use the word recipe. Recipe for what qualifies and what elements a report needs to persuasively demonstrate in order to qualify as substantial medical evidence. And we'll go over a couple of key citations from the Escobedo case as relates to substantial medical evidence here in just a couple minutes. Now, a little quotation here from the Granado case. The Granado case concluded, and this was, like I said, this one dates back, to 1970.
In Granado, they concluded that a medical report is not substantial evidence unless it sets forth the reasonings behind the physician's opinion, not merely the conclusions. So here's the key word, the reasonings. The reasonings behind the doctor's opinion or the doctor's conclusion. So let me give you just a little bit of heads up as to where we're going. If reasonings are so important, then what we're going to do is after each and every opinion and conclusion that we offer in our report, we're going to follow that up with a paragraph that begins by stating, my reasons for this conclusion include, colon, and then some bullet points down below wherein you elaborate on the reasonings as to how and why you came up with this opinion and conclusion. Because simply conclusions without the reasonings to support those conclusions does not qualify as substantial evidence. And if you don't provide the reasonings behind your opinions and conclusions, your report, they can't use it. It's not substantial medical evidence. It's not substantiated to the point that the parties can rely on those opinions for the resolution of the case in chief. Now, in the Zemke case, and this was a 1980s case, I believe, in the Zemke's case, the important quote for our purposes that came out of the conclusions of the Zemke case was that substantial evidence cannot be based on a legal conclusion that does not furnish a basis for the finding. So we might even use that term in support of our opinion and conclusion. We might say, my basis for this conclusion includes, colon, and then some bullet points underneath to provide the bases upon which you arrive at the conclusion. See, the parties are going to look at your reasonings and they're going to look at your bases in order to determine if you're using correct principles upon which to base your opinion and conclusion. So let's talk about Escobedo, and then we'll get actually into the actual text of the Escobedo case. In Escobedo, substantial medical evidence was defined as following. Escobedo stated that, number one, an opinion or a conclusion must be framed in terms of reasonable medical probability. Reasonable medical probability. So that gives us a clue. Whenever you provide an opinion or a conclusion, one of the bases or one of the reasonings behind your opinion and conclusion is that it's based upon reasonable medical probability. In other words, it means that in your opinion, doctor, in your opinion, this conclusion is more likely than not. It's reasonably medically probable. Probable means 51% or greater. Number two, the opinion and conclusion must not be speculative. Must not be speculative. Must not be based on speculation. Must not be based on guess. Must not be based on conjecture. It must be based on some solid fact, some solid factual, historic, or medical record or physical exam basis. There must be some factual basis for the opinion or conclusion, not simply based on guess, speculation, or conjecture. And I'm sure you're familiar with speculation and conjecture. Many times when people sit around and talk and just chat informally, they talk back and forth about a variety of topics, not all of which are firmly based in anything factual at all. In fact, I frequently talk with my wife about various topics over the dinner table and what have you, and she frequently says to me, well, that's speculative, and I frequently will say to her, well, that's speculative. And it's true. We say a lot of things that are based on speculation, but that does not fly with our QME reports. And anytime there's a hint of speculation or conjecture, that does not qualify as substantial medical evidence. Okay? And I'll show you how you can use the speculation checkpoint when it comes time to check your own QME reporting. Number 3, it must be based on pertinent facts. Pertinent facts. Pertinent and relevant facts. So when you provide your opinion and conclusions, cite the pertinent facts upon which you're basing your opinion. And see, really, this is a valuable exercise for us to go through as evaluating doctors, because it serves as a validity check for ourselves to make sure that, indeed, when we provide our opinions and conclusions, they have some basis. They have some reason behind them. They have some factual basis. And it's a good exercise for us to actually review the factual bases, not only to ourselves, but also to the parties, so that they can indeed see that we're relying on correct principles. Okay? Number 4, it must be based on an adequate examination and an adequate history. So always take a good history. Always do a fabulous exam. A fabulous exam. Now let me tell you this. The reader of your report, even a non-medical person, can tell the quality of your examination. Can't you tell the thoroughness of a doctor's examination when you read their physical exam section of their report? Can't you tell what procedures they did, what procedures they didn't do, what procedures were omitted? Can't you tell upon what information in the physical exam they're relying when it comes time to reading the opinions and conclusions? Can't you tell when an opinion or a conclusion does not have adequate basis in the physical exam section? In other words, your physical exam section should support your opinions and conclusions. The pertinent facts of your physical exam lead naturally into your opinions and conclusions. And it's only when your physical exam is fabulous. Fabulous. Did I say fabulous? Your physical exam should be your pride and joy. The physical exam section of your QME report should be a masterpiece of thoroughness, of detail, of meticulous attention to every detail. No physical examination procedure undone, no objective test undone, uncompleted, no measurement left undone, no physical examination procedure fabricated after the fact. Your physical examination should be perfect. You never leave the physical exam with a single objective test undone. Your physical examination section is your representation of your body of work. It should be of something of which you're most proud. Okay? So, and Escobedo even said it must be based on an adequate examination. If you don't have adequate examination findings to support your opinions and conclusions, you're toast. Your QME report is toast. The opinions and conclusions have no value. So I want you to focus on improving your physical exam. Finally, Escobedo said that for an opinion or a conclusion to qualify as substantial medical evidence, we as the doctors must set forth the reasoning in support of those conclusions. Reasonings in support of those conclusions. Now it's interesting, sometimes in this type of work that we do, things are not always black and white. There's many shades of gray, and there's some areas where there is some uncertainty, and many times we cannot be always correct, or we not always 100% right. Sometimes, how do we know when we're right? In the medical business, it's sometimes not possible to be right. In fact, the very word diagnosis has some uncertainty in it. The word gnosis comes from the Greek verb don't know. We don't know. But in the QME report, when you provide an opinion and conclusion, whatever that opinion or conclusion is, Even if it's not right, at least be right in being wrong. At least support your opinion, even if it's totally wrong. You can be totally wrong as long as you support your opinion and conclusion. And the parties might look at it and they say, well, that's completely wrong, but that's what the guy believes. But now we know what he believes. We can work with it, even if it's wrong. See, in that sense, you take a stance, either black or white, and it's okay to be wrong, but support your opinion, whatever it is. Okay? Okay, so let's now take a look at the Escobedo case and have it up here on the screen so that you can follow along with me. And I'm not going to beat this point to absolute death, but I want to highlight the key citations in this case that relate to what we're talking about with regards to substantial medical evidence. And in this case, the Escobedo case points particular emphasis towards the permanent impairment determination and then, of course, the apportionment determination. And these are the areas where your opinions and conclusions are most closely scrutinized. That is, your permanent impairment determination and your opinion on the causation of the permanent impairment. So, of course, both of those opinions need to qualify as substantial medical evidence. But the theme of today's program is that all of your opinions and conclusions have to be substantiable and have to be reasoned and explained as to how and why you came up with your opinion or conclusion. Okay, so Marlene Escobedo was working at Marshall's department store. She suffered a right knee injury, and she had a qualified medical evaluation. And the qualified medical evaluator, the defense qualified medical evaluator, disagreed with the primary treating physician. The primary treating physician provided a permanent impairment opinion, but did not apportion any of the permanent impairment to pre-existing degenerative arthritis of the knees. And Marlene Escobedo was found to have permanent impairment of both knees. Well, the defense filed a petition for reconsideration, and what they based their petition on was they claimed that the qualified medical evaluation, the applicant attorney filed for a petition, and he stated that the QME's opinion that the applicant's pre-existing arthritis contributed to part of the permanent impairment. He claimed that his argument did not constitute substantial medical evidence because it failed to explain in adequate detail how the pre-existing degenerative change caused permanent disability. So that sort of sets the framework for where we're going. So in this case, we're dealing with substantial medical evidence as it relates to the apportionment of the permanent impairment. So let me pick out some of the key citations from the Escobedo case. It said that apportionment of permanent disability caused by other factors is possible, provided that there's substantial medical evidence establishing that these other factors have caused permanent disability. So with regards to the apportionment determination, any opinion that you render must be substantial, and we'll talk about the factors that contribute to substantial medical evidence. They concluded that even where a medical report addresses the issue of causation of the permanent disability, and even though you do make an apportionment determination according to Labor Code 4663A, the report may not be relied upon, and maybe this should say cannot be relied upon, but they say that the report may not be relied upon unless it also constitutes substantial medical evidence. Okay, so we're developing our theme that one of these two doctors who opined in Marlene Escobedo's case provided an opinion that was substantial and the other one did not, and the one with the more substantial opinion is the one that prevailed in this now landmark case. Okay, so scrolling through just to get to our point. They stated that if the reporting physicians disagree, and in this case we had two reporting physicians, both of whom they disagreed with each other, they disagree regarding the overall level of permanent disability and/or regarding the approximate percentages of industrial and non-industrially caused permanent disability, then the board or the judge must weigh the evidence appropriately and determine these issues based on the most persuasive, substantial medical evidence. And the whole purpose of this video is to arm you with the tools that you need so that when it comes to these difficult determinations, yours is the report that becomes the most persuasive and the most substantial. Now, here's a key quotation from the Escobedo case. They state that the criteria that a medical opinion must meet in order to constitute substantial evidence on the issue, number one, of permanent disability, and number two, on the issue of causation of the permanent disability. We're going to get to those criteria below, but they specifically state here that these criteria relate to permanent disability and to the causation/apportionment of the permanent disability. So I'm going to give you some key phraseology that you can cut and paste into your report after your permanent impairment and after your causation sections in your report, where you can summarize those two sections and demonstrate to the parties that your opinion on both topics are substantial. Okay, so let's come to the conclusion of the Escobedo case, at least with regards to substantial medical evidence. If a report addresses permanent disability and the causation of it, still the report may not be relied upon unless it constitutes substantial medical evidence. All reports and decisions must be supported by substantial evidence. So here comes our criteria. It's been long established that in order to constitute substantial evidence, a medical opinion must be predicated on reasonable medical probability. And that goes back all the way to the beginning of time, even with cases in 1968, 1949, 1993, etc. Also, a medical opinion is not substantial if it is based on facts no longer germane, on inadequate medical histories or examinations, on incorrect legal theories, or on surmise, speculation, conjecture, or guess. And there's the Zemke case that I referred to earlier. The Granado case concluded that a medical report is not substantial evidence unless it sets forth the reasoning behind the physician's opinion, not merely his or her conclusions. So really, we take our recipe for substantial medical evidence right out of these sections here. And I'll summarize those for you in just a second. Finally, they state that the chief value of an expert's testimony rests upon the material from which his or her opinion is fashioned and the reasoning by which he or she progresses from the material to the conclusion. And you need to demonstrate that to the parties, doctors. You need to demonstrate your reasoning, and you need to demonstrate your progression all the way to the conclusion. And it does not lie in the mere expression of the conclusion. Thus, the opinion of an expert is no better than the reasons upon which it is based. Remember, we said that the mere expression of the conclusion, we refer to that as conclusory. In the context of apportionment determinations, the medical opinion must disclose familiarity with the concepts of apportionment. It should describe in detail the exact nature of the apportionable disability. It must set forth the basis for the opinion. That way, when you do those things, when you describe in detail and when you set forth your basis, the board can then determine whether or not you're properly apportioning under correct legal principles. If you don't detail this out and describe this out in advance, they have no way of knowing how you arrived at your conclusion and whether it's based upon correct legal principles. So finally, with regards to apportionment, in order to qualify as substantial medical evidence, a medical opinion must be framed in terms of reasonable medical probability. It must not be speculative. It must be based on pertinent facts and on an adequate examination and history, and it must set forth reasoning in support of its conclusions. Basically, it needs to explain how and why, in this case, with regards to apportionment, how and why the disability is causally related to the industrial injury, and how and why, let's highlight that, how and why the injury is responsible for some other portion of the disability. How and why are our key phrases. So in this case, they found that the defense doctor who opined that 50% of the permanent impairment was due to the pre-existing degenerative arthritis of the knees, they found that his opinion qualified as the more substantial of the two opinions, and his finding for approximately 50% of the permanent disability was held up. Okay, doctors, so that's the Marlene Escobedo case. Let's summarize this, and let me give you some tools that you can use in your very next QME report. So I have here open a QME report template, and this is a female template. And you see that I've opened my template to the permanent impairment section of the report. And in this section, I have all of the permanent impairments set up both under the old system and under the AMA Guides 5th edition. And so let's just scroll through this here. You'll notice that I have all of the DRE and all of the range of motion method spinal impairments already set up in here. I have impairments for all regions of the spine already set up here. Here's the range of motion method. It's already set up. All the upper extremity impairments are already set up. All the lower extremity impairments are set up. I have a comparison table here for providing for either upper or lower extremity permanent impairments by analogy to the other extremity. In other words, providing for upper extremity impairments by analogy to lower extremity impairments. Permanent impairments due to work restrictions, loss of pre-injury capacity if we're using the 1997 Permanent Disability Rating Schedule. And anyway, so this section would simply be completed with information specific to the examinee. And then we get into the apportionment determination, which it looks like my apportionment section here has gotten a little bit abused. Let's see if we can fix this. Go down to our apportionment determination. Yeah, there it is. Okay. And I'll show you how we do the apportionment determination. Okay, so here is the apportionment, and let's call this the causation / apportionment of the permanent impairment section of our report. Okay, so this section is already set up. I have the labor codes 4663 and 4664 set up here for my reference. And so anyway, you make your apportionment determination, and whatever it is, whatever your opinion is in the very end in this section, you conclude these two sections, the permanent impairment section and the causation / apportionment of the permanent impairment section, with your statement of substantial medical evidence. And this is the same criterion as we described earlier, but here you see how it's cut and pasted into your report. So let's simply go through this one more time to solidify this concept. You state here that the above opinions on permanent impairment and the causation / apportionment of the permanent impairment, and that's exactly the way it was described in Escobedo. Both permanent impairment and the apportionment determinations have to qualify or constitute substantial medical evidence. So here's where you tell the parties that the above opinions are based on reasonable medical probability, not certainty, but probability, and my professional experience. And let me highlight that for you. Probability means greater than 51% chance of occurrence. It's based on an adequate history as provided in the medical records and is clarified by Mrs. Jones. It's based on my physical examination of Mrs. Jones on 1/1/2010, 2/13, 2013, and 1/29/2015. If you saw Mrs. Jones on 3 separate occasions, you would fill in those dates right here. Your opinion is based upon review of the available diagnostic studies. It's based on medical research into the findings of the diagnostic studies, if that statement applies to you. If not, you would simply highlight that and delete it from your statement. And any follow-up consultation that you might have with a medical radiologist, electrodiagnostic testing technician, or interpreting physician, or any other consultation, you would fill that in right here. And then finally, you need to review your opinion and make sure that none of your opinions are based upon anything related to speculation, conjecture, surmise, or guessing. And compare your opinions against these criteria. Only when your opinions are satisfied by each of these criteria, or in other words, only when your opinions satisfy these criteria is your report ready for your signature. So doctors, when you add this statement of substantial medical evidence to your reporting, it makes your reporting so much more powerful in a couple of different ways. First of all, it indicates to the parties that you're familiar with what substantial medical evidence is, that you're familiar with Escobedo and the standards that are espoused by Escobedo, and also because it allows you to serve as a check and balance system against which you compare your report to make sure to your own satisfaction that indeed your report meets all of these criteria. And if you yourself are not comfortable that your report meets these criteria, then certainly your report is not ready to be sent out. Now, let me just say one more thing before we conclude this program. If you've ever been in deposition, the reason that you're at deposition is because one or more of the parties have some disagreement over one or more of your determinations, and that typically falls upon your determinations for permanent impairment and or the causation / apportionment of the permanent impairment. I mean, those are the two basic money categories of your report. And if you're called to deposition, it's because somebody has some disagreement with one or more of your opinions. And one of the ways that the parties will try to either verify or reinforce your opinion, or to negate or tear down your opinion, is by demonstrating to the trier of fact, meaning the judge, that your opinions are not substantial medical evidence. So, for example, if you have an attorney who wants to try and help support your opinion or help defend your opinion, in other words, he's happy with your opinions, he may try to demonstrate that indeed your conclusions are substantial. So that line of questioning could go as follows. Doctor, did you take a history from Mrs. Jones during your face-to-face evaluation? Your answer would be, yes, I did. What's he trying to do there? He's trying to demonstrate that your opinion is based on an adequate history. The attorney may ask you, Doctor, did you do a physical examination of Mrs. Jones on 1/29/2015 during your qualified medical evaluation? Your answer to that would be, yes, I did do a physical examination. What's he trying to demonstrate? He's trying to demonstrate that your opinion is based upon an adequate physical examination. He may ask you, Doctor, did you review any available diagnostic studies? your answer would be yes. And he would follow that up and say, well, tell me what you reviewed. And you'll tell him. And he'll ask you, did you have a chance to review the June 24th, 2011 MRI studies? And you can simply say, well, yes, I did, if you did. And what's the strategy behind this line of questioning? Is to demonstrate that your opinion is based upon a review of the available diagnostic studies. They may ask you, doctor, did you have any follow-up consultations? You can say, yes, I did. They can ask you, doctor, is any part of your opinion based upon speculation or conjecture? If so, which of those opinions are? And you simply would say, no, none of my opinions are based on speculation or conjecture. They're all based upon reasonable medical probability and my professional experience. And in that situation, the attorney is attempting to qualify your opinions and your conclusions as substantial medical evidence. Now, you can expect it to go in the other direction as well if one of the parties disagrees with your opinions and conclusions, and they may try to find loopholes in your opinions and conclusions to demonstrate that, in fact, your opinions and conclusions do not qualify as substantial medical evidence. So, doctor, make sure you never, ever, ever send out your report signed if your report does not satisfy these 5 criteria to the point that you are comfortable being called to deposition if one or more of the parties should disagree with your opinions and conclusions. Okay, so I hope you enjoyed that video presentation on substantial medical evidence. Let's conclude this important topic with just a couple of summary statements. And I want to show you how you can incorporate the concept of substantial medical evidence into your QME report writing to ensure that indeed, prior to sending out your QME report, that you've checked and double-checked your opinions and conclusions to ensure that indeed they do match up to the criteria as described in the Escobedo and Zemke cases at least. So in considering your opinions and conclusions will qualify as substantial medical evidence when, number one, your opinions and conclusions are based on reasonable medical probability and your professional experience, meaning that it's reasonably medically probable that your opinion and conclusion has a greater probability of being true and accurate than the converse, than being untrue or inaccurate. And this is one of those great latitude statements that we can use to support our opinions or conclusions. And when you review your opinions and conclusions, you need to reassure yourself that your opinion is reasonably medically probable, meaning that it's more likely than not. In other words, it's based on all of the information and all of your professional experience and all the knowledge that you have as a medical / chiropractic / psychologic / whatever specialty you are providing the evaluation in. It has to be based on the sum total of your knowledge and your professional experience. And in your opinion, it has to be more likely probable than not. So that's the first great summary statement of substantial medical evidence. Number two, your opinions and conclusions are based on an adequate history as provided where? Well, where do you get the history from? Well, it's provided in the medical records, and later on the medical history is clarified by your examinee. And earlier in the program, I talked about how to obtain both the history and the relevant medical history by comparing and contrasting information that's provided in the medical records with information that's provided by the examinee. Now, this is one of the summary statements of the Escobedo case, which stated that substantial medical evidence has to be based upon an adequate history and an adequate physical examination. So here we are, we're breaking out the history and we're breaking out the physical examination. So summary statement number 3 states that my opinions and conclusions are based on my physical examination of Mrs. Jones as the qualified medical evaluator. Now, if you're the agreed medical evaluator, replace the word qualified here with the word agreed. Now, if you've examined Mrs. Jones on multiple occasions, and you'll know that that's not unusual because sometimes we see these examinees 2, 3, 4, 5, and even more times. So if you have seen Mrs. Jones on multiple occasions, here is where you would input those dates. So for example, you would say my physical examination of Mrs. Jones dash 3 times, open parenthesis, 1/1/2012, 11/30/2012, comma, and 6/16/2014, close parenthesis, dash, as the qualified medical evaluator. And doctors, do you see how powerful that phrase is? That indicates to the parties that your opinions are based on your 3 exhaustive, lengthy, and thorough physical examinations over a period of time on Mrs. Jones. That is such a powerful statement because it indicates to the parties the hours and hours and hours and even months and years of thought that you have into the particular case, all of which collectively combine to contribute to your opinions, which in your opinion are substantial medical evidence. Summary statement number 4 is that your opinions and conclusions are based on a review of the available diagnostic studies. And if you've taken new diagnostic studies or ordered any new studies, you would indicate those here. So, for example, the phrase would say, it's based on a review of the available diagnostic studies, dash, including new x-rays and upper extremity electrodiagnostic studies ordered for this evaluation, dash. If you perform any medical research into the findings of the diagnostic studies, indicate the summary statement of that here. And if you've had a follow-up consultation with any specialist, perhaps a medical radiologist, perhaps the neurologist who performed electrodiagnostic studies, indicate the name of the specialist right here and include that action here in this summary statement. And can you see the power and the convincing ability of that statement? It indicates to the parties that, my God, you've got a lot of consideration and a lot of research and a lot of study into your opinions and conclusions. Finally, summary statement number 5 is based on Escobedo and the Zemke cases, and that is that your opinions and conclusions are based on reasonable medical probability and does not rely on speculation or conjecture. Now, it's important, doctor, that this simply not be a rote templated statement, but that your opinions and conclusions actually comply with these dictums and comply with these dictates. So you need to review your opinions and conclusions and work on those that seem to be speculative, and work on those that seem to be based on conjecture, and work on those that seem to involve any element of guess. And if you locate those opinions and conclusions that are not based on reasonable medical probability, you need to rework those opinions and rework those conclusions so that they are substantial and they're in no way speculative and they're in no way conclusory. And remember, we define the word conclusory as simply an opinion or conclusion without any support behind it. And according to Zemke and Escobedo, conclusory opinions are really of no value to the parties. they can't use them. So you need to review all of your opinions and conclusions and cross-check and cross-reference them against these criterion before you put a stamp and a signature on that report and send it out in the mail.
Okay, so let's conclude and summarize this section of the program. Recall that the title of this section of the program is the required elements of the medical legal report. And I hope by now you're impressed that the medical legal report in California workers' compensation is its own unique animal. It's much, much different than any report that you might write in your clinical practice. It's much different than any report that you might write for, say, for example, for a personal injury case or a Social Security disability case, etc. It's its own unique animal, and many of the aspects of the medical legal report are governed by law. So let's just review the important references that relate to the production of the medical legal report. We have the 2016 Physician's Guide, and you should have your copy of this document. We have also the AMA Guides 5th edition, which is not so much specific to California workers' compensation, but it's specific to the permanent impairment evaluation, which is a component part of the medical legal evaluation here in the state of California. So we can extract some valuable content from the AMA guides. CCR 10682 is quoted in the 2016 Physician's Guide, and you can look this regulation up yourself. You can simply Google CCR 10682, and this regulation is the regulation that tells us what components must be in our medical legal report. And then a couple of regulations that deal with the production and the writing of the report. Importantly is CCR 35.5 and then Labor Code 4628. And these have to deal with our obligations and our responsibilities and really what it is that we're supposed to do when we write our QME report. CCR 35.5 tells us that the purpose of the medical legal report is for us as medical evaluators to answer questions, to answer the questions that the parties hire us to answer. And the parties provide to us their questions in the form of cover letters. So we're required to address all questions in the cover letters. Now you're going to find that this is a skill that perhaps is underdeveloped in you as a medical treating practitioner. This is not a skill that you've had the opportunity to develop as you go about the development of your clinical practice. But this is a skill that you will increasingly develop and sharpen as you write more and more QME reports. It's a unique communication skill to be able to provide the parties with the exacting and specific answers that they're seeking. Labor Code Section 4628 tells us that most of the aspects of the medical legal evaluation must be done by us as the doctors. We're the persons who sign the report, and the person who signs the report has many responsibilities, and those are described in 4628. 139.3 is one of the disclosures that deals with non-specified financial interest. You should read all of these codes and all of these regulations because, of course, this is simple material for testing, and the DWC just loves to test on these various labor codes and codes of regulation. Finally, the concept of substantial medical evidence is something that you're going to employ in every single evaluation that you do, because in this system, every time you offer an opinion or conclusion, your opinion and conclusion must rise to a certain level. It must rise to the level of what's called substantial medical evidence. And a substantial opinion is much different and much stronger and much more accurate and more likely true than any old opinion offered by any medical evaluator. So substantial medical evidence is something that you need to learn, that you need to embrace, and that you need to employ every time you offer an opinion or conclusion. So that concludes session 2 of this program. Let's now move on to our next session.